Hi, everybody. I'm Diane Brady. The Supreme Court recently made a decision to pause the deal that Purdue struck in bankruptcy court that would have involved basically resolving the Sackler's claims over opioid abuse. That's OxyContin. And there are a lot of similarities with other cases out there, most notably Johnson & Johnson and the talc case related to cancer. With me is Jon Ruckdeschel. Jon, I hope I got that correct in terms of my expression of what's going on. You are one of the trial lawyers who moved to dismiss these cases from bankruptcy court. Let's first start with where the similarities lie between these two cases.
The key similarity here with Johnson & Johnson's attempt to manipulate the bankruptcy system and the Sacklers is the fundamental point that they're trying to use the bankruptcy courts to get bankruptcy relief without actually filing for bankruptcy and subjecting themselves to the oversight of the court. So the Sacklers individually and Johnson & Johnson, the corporate parent that also used to run the talc business, are identically situated in the way they're trying to manipulate the bankruptcy courts and the bankruptcy system to essentially avoid scrutiny from the courts and from the claimants that they've harmed.
Let me, the Texas two-step. This is in essence, let's describe what that is, because this is not something that is unique to Johnson & Johnson or to Purdue. Describe for us what that is.
Sure. So there's an obscure Texas law that allows companies to split themselves into one or two or more companies and then assign assets and liabilities between them. And so what Johnson & Johnson did and what Georgia Pacific has done and 3 or 4 other companies with massive asbestos liabilities have done is they've gone ahead and created a stooge subsidiary. They on paper moved to Texas for an instant, and then they divide the company into two, and they move the bad company with all the asbestos liabilities to North Carolina, and they move the good company with all the assets and all the money back where it came and rename it itself again like nothing ever happened. And so in doing that, they can isolate the liabilities and then put the stooge into bankruptcy.
Well, let me talk about some of the key differences here. One being Purdue essentially was a single product company with OxyContin. J&J is a massive corporation with a multiplicity of products. And from a shareholder perspective, you could see a logic to containing the liabilities. And in essence, by doing that, I wonder if there's an argument that you would speed up the resolution. Is that not an argument that you think would hold water? Obviously you don't, you've moved to dismiss it, but it would seem there's an efficiency argument in favor of J&J in this case.
So that's an argument that J&J wants to make. The problem for Johnson & Johnson itself is it directly ran the talc business until 1979. And then it created a subsidiary that ran it from there forward, while J&J, the parent company, continued to maintain all of control over safety and health. And so this is wrongdoing that was done directly by Johnson & Johnson, that Johnson & Johnson is trying to wash through the bankruptcy filing of a subsidiary that has its own liability. So really, they're trying to do exactly what the Sacklers are doing in Purdue, which is their company has filed for bankruptcy, but they want to be exonerated for their individual alleged wrongdoing while keeping the majority of their money.
And capping future losses and future suits. But, I mean, one of the things that's interesting here is that we had sign-off essentially on the Purdue-Sackler deal, and it's now been paused for the Supreme Court to hear it. J&J, this has been consistently rejected. Am I correct? This particular strategy of using the bankruptcy court to contain these liabilities. So it doesn't seem like it's really working for them.
Well, the Third Circuit rejected their attempt to do this soundly when it first went up to the Third Circuit Court of Appeals, and made it very clear that the bankruptcy system is for companies that are in financial difficulty. I mean, that's sort of a duh kind of ruling from the Third Circuit, but that's what we all know. Bankruptcy is not for the super wealthy who just want a better deal. And that's what J&J wanted to do. It has complaints about the fact that the court system and juries get to decide liability. Well, that's the way our government's set up, and that's in the Constitution. And so the proper way to deal with that, if you have a complaint about it, is not to manipulate the bankruptcy system, but to go to Congress and try and get a law passed that addresses those concerns or amend the Constitution. But all of us as Americans have rights, and if we're harmed by somebody, we have a right to a jury trial to ascertain the liability. And people that hurt other people, whether that's with opioids or asbestos products, they all complain about the inefficiency of the tort system, the inefficiency of going to court. But that's the genius of our system of government. We let citizens decide if companies have been negligent. And unfortunately for J&J, they don't like that because juries don't believe the lies that they're telling in court about their product not having asbestos.